I guess I just wanted to start out by saying that I hope everyone is doing okay in this very difficult time, or as okay as can be expected. This is an incredibly difficult time for all of us. Everything has been upended. We are living through a sort of a really extraordinary set of events. Our relationships with one another have been drastically changed. We can't touch, we can't hang out in person, we can't gather in classrooms together. Our everyday routines have also been profoundly altered. And I think I speak for all of us when I say we either are living in fear, or if not, at least tremendous uncertainty about what the future brings. The public health term for what we are living through right now is a global pandemic, right? But the legal term for what we are living through is not pandemic, it is state of emergency. Now, a state of emergency is a period of time in which, in response to a natural, an economic, or a political crisis, the ordinary rules that govern daily life are suspended and the government gets powers that it otherwise lacks. Powers that it is supposed to use to protect the people against the natural or economic or political difficulties that threatens them. It is because we are in a state of emergency that Governor Pritzker can impose a stay-at-home order, like the governors of most states, without immediately being impeached and thrown out of office. And it is because we are in a state of emergency that President Trump can invoke the Defense Production Act and use it to force companies to do the federal government's bidding. And it is because we are in a state of emergency that many other ordinary rules, both big and small, have been suspended or profoundly altered. And we can think about tons of rules that have been changed right now. I mean, I think from both the very big to the very little, things like immigration rules, right? The suspension of immigration in certain domains, to things like parking rules. The ordinary parking rules that apply in the city of Chicago have been suspended. Okay, these are all the hallmarks of a state of emergency. Now, recognizing that we are living in a state of emergency does not mean that we are living in what the political theorist Carl Schmitt called a state of exception. And it is very important to distinguish the two, which are frequently confused. So Schmitt defined a state of exception to be a period of time in which the ordinary constraints imposed on the government's power are lifted. Schmitt was really interested in executive power and the lifting of controls over the executive, but I'm going to generalize here, although I will note that most of the exercise of power we're going to be, I'm talking about today and that we are thinking about right now is executive and not legislative in nature. And it is interesting to think about why it is during these periods of time that the legislature takes such a secondary role and the executive comes to the fore. But that's not important right now. So for our purposes, it doesn't matter whether it's the legislature or the executive. What defines a state of exception generally is that it is a period when the government is free to act as it desires without all of the annoying checks and balances that otherwise can make it difficult to do so. Now, a state of emergency can lead to or blend into a state of exception. A crisis occurs and the government claims not only that some of the rules that govern ordinary life need to be suspended, but that it needs total power, or at least much more power than it otherwise would possess, to address the crisis. And this becomes an incredibly effective argument for aggrandizing government power. After all, checks and balances, ordinary procedures, they do slow governments down. And I think this is why states of emergency and states of exception are often confused with one another, because the state of emergency is a precondition for the state of exception, so much so that governments that want to claim new kinds of power for themselves may sometimes engineer an emergency in order to do so. And I mean, the most famous example of this, I'm sure many of you are familiar with, is the Reichstag fire in Germany, which at least some historians believe was started by the Nazi government to justify the dismantling of the German democratic state and the rise to power of the Nazi state. Okay, so as this example suggests, for citizens and subjects of a democratic state like the United States, it is very important that we not confuse states of emergency and states of exception. It is very important that we not let the obvious and undeniable fact of an emergency like the COVID-19 pandemic justify the creation of a state of exception. And this is because, I mean, this is very obvious, but states of exception are totalitarian in nature. They are not periods in which democratic self-government is possible. They're not periods in which the ordinary transparency that characterizes the democratic state or should characterize a democratic state occurs. They are profoundly destructive of democratic values. It was because the fear of the threat that states of exception pose to democratic government that the US Constitution was intended to instantiate that, unlike many other constitutions, the federal constitution makes no mention of emergency powers and strictly enumerates the cases in which constitutional rights like the right to habeas corpus can be suspended. Okay, very narrow exceptions. And the framers of the document were right to be afraid. Although a suspicion of government power has been a pervasive theme in American political culture right from the beginning, and I'm sure as all of you are aware, it remains a very strong theme today, that suspicion dissipates a lot during times of emergency. I'm sure you've all felt this. I certainly have, that during emergency, citizens want the government to use its resources, to use its coercive power, to use its knowledge, to protect them against what they cannot protect themselves against. They want desperately to empower the government to act. And I think we've heard this so much in the last few weeks, right? That we want the federal government to exercise power. We want the federal government to act in all kinds of ways because of this belief that you need strong exercise of government power in response to these kinds of crisis or emergency. And I think it can be a very good thing, this impulse. One of the best things about emergencies, if one can speak about the good things about emergencies, but one of the good things about emergencies is that they remind us of our interdependency, and they remind us about the reasons why government exists. Government exists, or ideally should exist, to act in our collective self-interest, to do the things that are necessary to enable individual flourishing, but that individuals cannot do for themselves. Okay, so this is all good. The impulse for the government to act reflects, I think, a deep truth about interdependency, solidarity, and the reason for the state that feels profoundly true during these periods. But it can also be very dangerous if it is used to undermine democratic values or empower the government to infringe on civil liberties. So the job of all of us, okay, I think the job of ACS right now in a sort of a very pronounced way, but for everyone in this room, for all lawyers or law students or anyone interested in democratic values, I think the job is to patrol the line between emergency and exception, okay? To recognize that these are unusual, extraordinary times in which we want the government to be able to act forcefully, but that these are not times in which we want to sacrifice our democratic rights or our civil liberties. Okay, so what does this mean? Okay, so far this has been very abstract and theoretical, very University of Chicago, but I want to bring the discussion down to earth by connecting it to my topic for today, which is religious liberties in a time of pandemic. So I think the distinction between exception and emergency provides the analytic framework I want to use to think through what it might mean to respect religious liberties at a time of pandemic. And not only religious liberties, the analysis applies to other kinds of liberties. I'm happy during Q&A, or if we have time, to talk about free speech as well. Okay, so as a general matter, what this frame suggests is that the ordinary rules that govern how religious groups pray, collectively associate, or otherwise operate in public and private may be altered when necessary to prevent public harm or in response to this emergency, okay? That emergency does change the legal framework in all kinds of ways, and this is true as applied to religious groups and religious liberties as applied to everything else. But that every person in the United States continues to possess their federal constitutional right to the free exercise of religion, as well as their right against the state establishment of religion, as well as whatever rights state constitutional law provides them, just as they did before the emergency, okay? State of emergency means that the way in which we apply the rules may differ, but it doesn't change the fundamental fact of the rights that we possess. Okay, still pretty abstract. Okay, I'm getting more concrete. So what that means is that even in a state of emergency, the government cannot unnecessarily or irrationally infringe on people's ability to pray, to engage in religious ceremonies, or to congregate together. And it may not discriminate against anyone because of their faith or their lack of faith or the nature of their faith. And it cannot prefer some religions to others. Okay, these are the sort of the basic principles of First Amendment religious liberty, free exercise jurisprudence, and they are rock solid. Okay, they cannot be altered by war, they cannot be altered by depression, they cannot be altered by pandemic. But of course, what they cash out to mean in practice will depend upon the actual circumstances of the day. To say that the government may not unnecessarily or irrationally constrain religious liberty may mean one thing under ordinary circumstances and quite another during periods of emergency. but in all cases, there must be a rational reason for the government to act. And if it acts by singling out or discriminating against religious groups or against religious practices in general, then the government has to show, really, it has an extraordinary burden on it. It has to show that its actions further a compelling purpose and that there is no more narrow means to achieve that end. The principles do not alter even if the facts and the circumstances do. Okay, so still very abstract, maybe a little bit less abstract, but I thought we could bring it down to earth by looking at some recent cases in which religious groups claimed that their constitutionally protected liberties had been violated. And I'm going to bring my own perspective to bear on these cases, but I really am curious to hear what your thoughts on these cases are, because they raise, as I think my discussion will make clear, really difficult but important questions about the meaning of these religious liberties right now. Okay. Maybe you all know that there has been, after I think a surprisingly quiet period when the stay-at-home orders were first instituted, where many constitutional people were, I think, quite surprised, both positively and negatively, by how little objection there was to the very stringent restrictions on sort of everyday practice that were imposed in Illinois and in New York and in California and across the country, right? There was this sort of dramatic change to our everyday life, and the usually very civil liberty protecting, very litigious American people seemed, in response to sort of, profound and very real fears about the pandemic, to not react. But as time has gone on, this has changed, the state of affairs has changed, and we're starting to see the return to a more ordinary constitutional frame where these pretty dramatic exercises of government power are being challenged on civil liberties grounds in all kinds of ways. And one of the primary ways, I think perhaps the primary basis of challenge to stay-at-home orders and their application have been in the name of religious liberty and by religious groups. And we're seeing these cases keep coming, and there's a ton of them, but I wanted to focus just on two to get sort of concrete. Okay, so the first case you may have heard about on the news. It's a case that involves a dispute between a church called the On Fire Christian Center and the Louisville mayor, or the Louisville government. So the Louisville church sought an order just before Easter. This was all very quick, last-minute litigation. That was enjoining, and it sought an injunction against Louisville mayor, preventing the mayor from enforcing an order that the church construed to ban their religious services that they plan to hold on Easter Sunday. And the religious services that they plan to hold were going to be not in-person religious services, in the sense that people were not going to be allowed to go into the church building and sit next to each other. That was considered, the church understood that was too dangerous. The likelihood of the transmission of disease was too high. So instead, the church had said that the worshipers, the congregants, they would come to the service in their cars, as the church had been doing during the course of the pandemic. And they would park, I think, 6 feet. There would be 6 feet between the cars, and they would roll their windows halfway down. And then there would be a minister in the front. I'm not sure if the minister was going to be in the car or in person, but otherwise everyone was going to be spaced out. And that is how they were going to do the service. Now, the litigation all started after the mayor gave a press conference, I think 2 days before Easter, in which he said a lot of confusing things. It wasn't clear whether or not he intended to enforce the order, but one thing he definitely stated was that he would ask the police to record the license plates of vehicles in attendance if the church did hold its services, so that they could follow up on this, what the mayor called dangerous public health practices. And so the suggestion was, well, church, if you're going to hold your services, we are going to have the police come and watch and record the license plates of everyone who attends and then follow up. And the church read this to be a very threatening act by the Louisville city government against what they understood to be perfectly safe, responsible, social distancing religious worship. So they asked the district court to enjoin the enforcement of the order, and the district court granted that injunction. Now, the district court's reasoning was not that, the problem with the injunction was not that it constrained religious liberty in some way. So the general rule of free exercise jurisprudence in the US for decades now is that the government actually has quite significant ability to impose constraints on religious liberty, on the free exercise of religion in all kinds of ways, so long as those constraints are part of a neutral, non-discriminatory rule or law. So the government can enact broad-based laws that happen to limit the ability of religious groups to engage in their practices, but so long as these laws are meant to apply to all kinds of groups, they're not targeted at any specific religious group or at religions specific, in general. There are, general obligations imposed on all members of society, whether they're religious or secular in nature. The courts are going to apply nothing more than a rational basis analysis, rational basis scrutiny, because they want the government to be able to do these sort of general purpose things. The worry really with free exercise cases is about discrimination. Okay, and so the district court enjoined the enforcement of the order not because it imposed some kind of burden on religion. The government has a lot of power under the American constitutional scheme to burden religion, so long as it burdens everyone equally. But because it found that the order was the enforcement of the order was going to be discriminatory against religion, because the city of Louisville had not prohibited what the court viewed to be similarly risky behavior, such as drive-by liquor stores or grocery shopping. So in Louisville, it was totally legal for you to, I didn't know that these existed, drive-by liquor stores, but you can drive to the liquor store and there's like a window and you can get your liquor and you move on. And so the court said, well, look, in both cases you're in your car, in both cases there's an effort to do social distancing, and yet the beer is permitted, but the religious service is not. And so the court said, well, if beer is going to be an essential service, then so too is Easter. And so it enjoined the enforcement of the order. And so the church had its services. So that's the one case. Now, the second case involved a megachurch named Legacy Church that was located in New Mexico and had nearly 20,000 church members. It had 3 different church buildings, but it had one major church building that had this very large auditorium. Now, the church sought a restraining order preventing, in this case, New Mexico's Governor Grisham, from enforcing an order that stated that houses of worship would no longer be exempt from the prohibition on mass gatherings that the state had put in place 5 days earlier when cases in New Mexico, COVID cases, started rising in numbers. Okay, so the original order had said that you cannot have any mass gatherings, and mass gatherings would be defined as any gathering of more than 5 people in a single room or outdoor space where individuals were within 6 feet of one another. It was a, I think, pretty well drafted order. It exempted from the definition of mass gatherings the presence of 5 or more individuals in a place where those individuals regularly resided. So, if you're a family with 6 people, you're not considered a mass gathering. But if you have a barbecue and people come and it's more than 5 people and you're within 6 feet of one another, under New Mexico law, as of April 6th, that's a mass gathering and is completely not permitted. But initially, there was the explicit exemption from this prohibition for things that would be mass gatherings but were religious services. So if you gather in a church or a synagogue, under the original order, you're not considered a mass gathering. On April 11th, though, the governor changed the law and issued a new order that got rid of the earlier exemption. So it applied only to religious gatherings, but it just said that these are going to be treated like mass gatherings like any other. It also specified, just as the earlier order had specified, that for retail stores, you could still have retail service, but any store, any grocery store, or I guess liquor store or store of that nature could only allow in 20% of the maximum occupancy as ordinarily determined by the fire department. So you could only allow in a small number of people, but it's not considered a mass gathering. Okay, so Legacy Church argued before the court that because it was a really big church with a really big auditorium and a lot of space, it should be able to hold in-person services and to figure out for itself how to do so safely without having to comply with this prohibition against mass gatherings. And it also argued that in order to stream its services, which it was going to do and it was going to encourage its members to use rather than in person, it needed to have more than 5 people, 5 technical people setting up the equipment and showing the video and recording the video, and they had to be more than 6 feet within each other. And so here too, if the church was going to be able to do its streaming services, it had to violate the order. And it argued more generally that the order was discriminatory because it treated retail stores differently than it treated religious groups. Insofar as retail stores, the requirement was not that everyone always stay within more than 6 feet away from one another, and there could be more than 5 people in a space at the same time. And so the claim here was just like the order in Louisville. This was discriminatory against religions because it treated like things differently, right? It treated retail stores and religious groups differently insofar as one was permitted and one was not permitted. Now, in the first case, remember, the district court granted the injunction. In the second case, the district court denied the injunction, okay? Now, it did so, there was a little bit of ambivalence about how it, about the ruling. The district court noted that there were two things about the order that gave it pause. The first was the timing of the order. The fact that the timing of the original order, which exempted houses of worship, meant that the synagogues in New Mexico could hold their Passover service, but that the second, that the April 11th order meant that the churches could not have their Easter services, raised the specter of anti-Christian discrimination or religious animus. And the court was expressed concern about this, but ultimately was satisfied that this wasn't evidence, although there, it raises this concern, the fact that cases of COVID-19 in New Mexico kept rising through this period, and there were more deaths, there was a doubling of deaths between April 6th and April 11th, meant that the most likely explanation was that this had nothing to do with anti-Christian animus, that this was instead just a part of the escalating response by the government, as one would expect. And so it was okay. And then the court also expressed concern about the apparent discretion that the New Mexico Secretary of State had under the law to classify and recategorize businesses as essential services or not essential services, and therefore permitted to continue to operate or not. And I think I think the court was correct to be concerned about this because, of course, the power to order certain categories of businesses to stay open or to close is a really significant power, and one might imagine that it could be used to all kinds of invidious ends. But in this case, the court found that the secretary had not used that power to reclassify very much. And in this instance, the only reason why the secretary had used that power was in response to an initial reluctance to constrain religious liberty that one might think is salutary given the sort of general protection of religious liberty under the Constitution, and a reluctance that eventually sort of the facts on the ground made too difficult to sustain. So the court concluded that the order was reasonable, it was non-discriminatory, it was only an incidental restriction on religious freedom and therefore could stand. But the court was careful to note that if there was evidence that the order was being applied in a discriminatory manner, then there would be big problems. Okay, so what do we think about these cases, right? Two relatively similar fact patterns, but two diametrically opposed results. In the first case, the court allows the injunction, issues the injunction. In the second case, it does not. Now, I think what is interesting about both cases is that they are both applying the same framework of law, that there is really no dispute about the governing principles. In both cases, the courts acknowledge that the government can impose even significant constraints on religious liberty when it's rational to do so, so long as it's neutral and non-discriminatory. And in both cases, they agree that the government may not discriminate against religion. In both cases, I guess I would say, the courts are trying to navigate this delicate line between emergency and exception to say, well, when we are analyzing these free exercise cases, and issues, we must take into account the fact that there is an emergency and that constraints on religious liberty that ordinarily would not be permitted are going to be completely fine in the case of the pandemic, but that does not mean that that there's no role for the courts to play in scrutinizing the government's justifications, as well as the ways in which the government is enforcing its orders against religious groups. And so I guess the general takeaway is that both cases make me feel pretty reassured about the role that the federal courts are playing in trying to maintain constitutional rights in a really extraordinary time. But the cases also illustrate, I think, how difficult it can be to put these kind of abstract principles into practice, And they make clear, I think, that even during a time of pandemic, there will be vigorous debate about what it means to exercise religious liberty, and reasonable minds can disagree. And I think this is particularly true of the first case. So remember the facts there. So the church had argued that the city had discriminated against religious groups by treating likes unlike, by treating equally risky religious and secular behavior differently. But in fact, photos that circulated in the local newspaper showed members of the church during a previous drive-in church service not obeying proper social distancing, even when they were nominally in their cars. Okay, and I'm going to see if I can show you. Okay, I'm going to share. I'm going to excuse. Okay. Can you see? Katie? Yeah, okay. So these are the photos from the previous church service. So you can see that that's a, I guess, a member of the church seeking donations, not maintaining 6 feet distance.
Professor Lakier, I'm not sure if this is how it is on your screen, but it's the wrong
sideways.
direction. Yeah.
Yeah.
I don't know if you can fix that, but
yeah. No, I'm sorry. This is like at the max of my technological capabilities. So, okay. Uh-oh. And then the next one, see if I can get this. Okay, wait. I think I can rotate it. Okay, is that better? Okay, and the next one shows parishioners pretty close together, you can see, coming out of their cars, I think really experiencing this meaningful service, but the result is they're worshiping, they're praying pretty evidently, but they're very close together physically. And here's more, okay? You can see that precisely because this is a church service that is working, people are experiencing they're praying, they're congregating, they're collectively assembling, which is the whole purpose, that they're not maintaining such good social distancing. And it was in response to these kinds of photos that the mayor of Louisville issued the statement during the news conference, saying that he did not think that these drive-in church services were safe, and he did not think that the church was in fact complying with the CDC guidelines, and therefore that this was a violation of the Louisville rules. See people getting out of their church, out of their cars to worship. Okay. So although the court viewed the city as treating likes unlike, it is not at all obvious to me that this is in fact what was happening. Okay, it seems like the city was trying to treat unlikes unlike, that it was trying to treat what was in fact riskier social behavior differently than less risky behavior. Because there is good reason to think that sustained close interaction in large groups, as was happening during these church services, is much more likely to spread infection, and therefore much more dangerous than the kind of fleeting interactions in grocery stores, and particularly if we think about drive-in liquor stores that the city of Louisville allowed. So the first case may be an example of where even when we have the right framework, the court may still get it wrong if it's not paying close enough attention to the facts. Or rather, one might also alternatively characterize it as, given the same framework, different courts with different underlying presuppositions about how differential to be to religious liberty, or how differential to be to the government and its public health rationales, may reach very different conclusions about whether or not a given practice is or is not permitted. An example like this might lead you to think, I think if you're also public health oriented and think that the government should be able to act prophylactically, right? We're not exactly sure how the Sunday church service would have gone, but that the evidence from the prior church service suggests that this is likely to be dangerous, or could be dangerous, and therefore the government was allowed to act in that stead. That might lead you to think that the judicial review of religious liberties during a time of pandemic is a bad idea. Right, that the court got it wrong, and that the fact that the court got it wrong is evidence that courts should not be playing a role at all. But I guess I'll just end by saying that is the kind of thinking that gets us into states of exception and out of states of emergency. It's a very difficult task for the courts during times of pandemic to try and figure out the very fine line between not disabling the government from acting, but still exercising meaningful judicial scrutiny of its actions, such that the government cannot use this really extraordinary opportunity to do what governments sometimes like to do, which is use these moments of crisis to go after its enemies or to aggrandize itself to get powers it doesn't have. And so I guess I'll just end by saying that I think it's very important for all of us during this crisis to not forget that the crisis is not only a medical crisis or a public health crisis or a biological crisis, it's also a legal crisis and also an economic one. Okay, it is a crisis for the rule of law, in part because of the sort of really extraordinary circumstances that the government is facing. And for that reason, it's our responsibility, all of us, lawyers, law professors, law students, ordinary citizens, to be vigilant in checking, thinking about both how the government is exercising its power in the time of pandemics, and also how the courts are exercising their power to check it, because both can go too far. And the system of checks and balances that the US Constitution creates depends upon the both exercising their power imperfectly perhaps, but within their spheres to maintain a relative equilibrium between, on the one hand, coercive government power, and on the other hand, individual liberties. So I guess my takeaway is generally a positive one. Courts are doing the role that we want them to do, but also they're doing it perhaps imperfectly. And the result is going to be that there are going to be cases in which perhaps we think the government should act and has the power to act and will not be allowed to act. But I think that's inevitable in any system in which we are going to both try and empower the government to act in response to emergency and protect our civil liberties. Okay, I'm going to stop here. I'm curious to hear your questions and comments. I guess I should say, Katie, how should we do it? Do people want to do the blue hand or just raise your hands?
I think we can do the blue hands.
Okay.
And if you can see them, people then can unmute themselves and hop in.
Okay, let me see if I can make it.
I also want to remind everybody that we are recording this, so ask good questions, not bad questions.
I see Jacob. So Jacob, do you want to unmute yourself and hop in?
Sure, thank you. Hello,
Hi,
Professor.
Jacob.
Glad to see you, and I hope you're doing, like you said at the beginning, as well as anybody can be.
Yes.
I was curious because I believe you mentioned that the court in the one case did not go into too much on question the state's differentiation between essential services. But do you think that could ever come up in a future case that different churches could challenge a state's decision that churches do not qualify as essential services, but maybe based on this other services they do allow to count as essential services, that could ever be a basis for a claim of religious discrimination?
Wait, so just say it again, explain it to me.
So do you think a church could ever make a claim that they're being discriminated against solely based on being determined not an essential service? So if a state created an essential service designation, allowed a book club or somehow allowed other things, would that ever be a source, do you think, of a discrimination claim? Or do you think courts would generally defer to the ability to create a list that it deems whether essential and not?
I think it's very interesting that the court in the second case went out of its way to note that this is that this unbounded discretion raised red flags for it. They wanted to express concern. So that makes me think that, no, it's not obvious to me that this is totally out of the realm of the things that courts could worry about. And I mean, I think that that's a good thing, right? The power to designate things as essential or non-essential is a really powerful instrument that the government has at its disposal. And you would want there to be some basis for the government to be making those kinds of distinctions. And so it seems to me perfectly plausible for just the framework I was talking about earlier. There can be neutral laws of general applicability that incidentally burden religion, that's okay, but we don't want to discriminate against religion. Or if you can show that the only reason we're excluding religious groups from religious services, say from the essential services category, is because of some kind of animus against religion, that seems like a perfectly good claim. It's just not obvious to me the decision making around what's essential and what's not essential seems like a very subtle and complicated judgment. Basically, the government wants to allow everything it can that's going to keep the economy running that isn't too dangerous. And there's going to be a lot of discretion involved in that judgment. And so I suppose I expect courts to be relatively deferential to those kinds of judgments, but I would hope that they wouldn't be totally deferential. There has to be some kind of reasoning behind it. We don't want the government to get a total blank check when it comes to these things. And so I was really happy that the court, I think that it reached the right conclusion in that case in not issuing the injunction against the enforcement of the New Mexico order. But it was very careful to do it. And so I think that's good.
Thank you.
Sure. Josh?
Hey,
Joshua?
so
Yeah.
I wanted to talk about the first example. You said the courts might have gotten it wrong because as we look at these pictures, people are, sending money, getting a little bit closer to each other than the ordinance said they could.
Mm-hmm.
I wouldn't be surprised if they maybe gave a hug or two. But under contract law, I know that there is a heeding presumption.
There's a what presumption?
A heeding presumption. So like
Mm-hmm.
people are expected to abide by the rules enacted by courts or legislature.
Mm-hmm.
Clearly here, that's not the case. People are just doing what they want and not abiding by the 6 feet rule.
Mm-hmm.
But do you think that courts can rely on that? Therefore, they wouldn't be necessarily wrong for giving them this privilege to have the service? Or is that specific heeding presumption strictly to contract law?
No, yes, I think the formal presumption is strict to contract law, but I think that is basically how the best way to explain what's going on in this case, by the way. The court is taking in good faith the claims that the church had made, and the church had said, we are going to follow CDC protocol, and we're going to keep 6 feet away, we're going to keep our windows half down. And although the government, the Louisville mayor, had submitted to the court those photos, so the court had those photos at the time it issued its ruling. This was amazing lawyering, by the way. There were like 3 different briefs within 24 hours. People did not sleep, I'm sure. It was very impressive on both sides. So the court had those photos, and they don't appear in the opinion at all. It completely discounted them. It didn't care. It didn't mention them. It didn't discuss them whatsoever. Didn't even say why it was discounting them. It just didn't talk about them. And so that's just to me that the court is doing exactly what you were suggesting, which is to say it's not going to use the past bad behavior as evidence of future bad behavior. The church is saying it's going to keep 6 feet away, it's going to keep its windows half down, and the court's just going to believe it. Now, that's unsatisfying to me, I have to say, because if there is evidence of past bad behavior, or bad behavior that happens to be risky in a time of a pandemic, and no explanation for why or what the church has done to prevent similar kinds of behavior in the future, right? The church just said that this is how we're going to run the service. They didn't explain, they didn't reconcile with those previous photos. It does seem like it's very formalist reasoning to say, okay, well, if the church said it, that's fine. Because, of course, the thing that we are worried about in all these cases is a spike in new cases and more deaths. And that doesn't depend upon what people say. That depends on what they do. And so it's unsatisfying to me that the court did not look at the reality and just took the church at its word. Right. But I think it reflects a deep deference to the institutional prerogatives of the church. And so if the church says this, then we're not going to disrespect them and pay attention to photos. So I think that's what was going on there. What do you think? If you were a court, what would you do? Would you pay attention to photos or not?
I mean, I would.
You would or you wouldn't?
I would. No. I agree with you. I would pay attention to the photos.
Mm-hmm.
I think that it's reasonable to assume that people will continue to behave in a way that they have in the past.
Mm-hmm.
But I can see how courts would be concerned with, a formalistic approach to policing populations. Like, even though they might have behaved this way in the past, maybe given the times, people will respect the rules. And I think that I've actually seen that, like here on my runs around Hyde Park, people do a really good job with, giving each other wide berths. But again, like I said, because they had evidence of their behavior otherwise, like I think that was weird that they ignored that.
Yeah, I mean, I think one of the difficulties of the framework that the courts use right now, which is the very much animus-based framework, we're going to give the government a lot of berth so long as we think it's acting in an, in a neutral way. But so long as we think that there's discrimination, the situation is very different. It means that a lot of the sort of the analysis depends upon a court's view about what's animus and what's not, what's reasonable for a government to do, what are the reasonable things that a government gets to, assumptions the government gets to make about future behavior based on past behavior, or what's reasonable in how you relate to a church or another religious institution, and what's not. And I do think that these kinds of judgments are going to depend tremendously based on your priors about the value of religion, the rule-following nature of churches, the public health powers of the government. And so just as is the case during ordinary constitutional practice, during pandemics, we're going to have like partisan splits. We're going to have a lot of fighting about the conclusions that courts reach. This is not a time when ordinary politics is suspended. It's just heightened in a way. And so I think the Louisville case, the case, really good example where that opinion, and there are, as I know, because it's just been endless fighting about it on the constitutional law professors' blogs and listservs, some people think the court completely got it right, that you do not disrespect religion by not listening to what the church says, which is it's going to follow CDC guidelines. And then other people think they got it completely wrong because, come on, we know what's going to happen. And given that, the government had an obligation to act. Okay, I can't see the queue, so who's next?
Michael Ortega.
Okay.
Go ahead.
Hi, Professor. Thanks.
Hi.
I'm curious about how you were talking just briefly now about how courts usually use like an animus framework in evaluating these cases.
Mm-hmm.
And I'm wondering about the role of kind of like traditional strict scrutiny, narrow tailoring, how that works in these religious liberty cases, given that the court can't like tell the church how to worship. So in these two cases, it seems like in the first case, the state is threatening the way that a church chose to comply with the kind of universal orders that are applied on all organizations.
Mm-hmm.
And in the second, the church in the second case is taking a stance like, we cannot do the services as we see fit
Mm-hmm.
if we are going to try to comply with the guidelines at all. And so the way that I understand it, if narrow tailoring is trying to get at is trying to force the state to accomplish the interest that it has while minimally burdening the rights at stake.
Mm-hmm.
How should courts, or are courts now thinking about that question when they're dealing with a right that they can't prescribe like the limits of?
Okay, hello, can you hear me?
We can still hear you.
Okay, yes, no, I think I got it. I got the shit. Michael, that's actually, I mean, that's one of the very difficult things about the religious liberties cases, that there's a way in which the thing we're protecting, the thing that we're trying to leave space for, is also something that courts themselves cannot evaluate, because if they're going to evaluate it, they're going to undermine the liberty. But so how that works, though, in most of these cases is that the court, it's not going to evaluate. So in the New Mexico case, the court said, the church said, we have an absolute right to, essentially, we have an absolute right to go about our religious behavior as we want to. And if you infringe on that right, then strict scrutiny applies. And the court, I think, said that's not the rule, because we're trying to not enter into judgments about what is a genuine religious practice or not genuine religious practice. None of the focus is on whether or not the government is infringing on a genuinely religious practice or, a crucial element of the religious service. It's all about whether or not the government is acting with animus or discrimination. This is the reason for the discrimination focus, because it puts all the focus on what the government's doing and the nature of the government's motivations, and makes and leaves off the table, prevents courts from having to evaluate whether or not religious practice is genuinely religious or crucial or important, such that it has to be respected. And so in some ways, I think the New Mexico case was really interesting because the church was making a claim that just isn't a good claim, is no longer a claim that can be made really powerfully in our religious exercise jurisprudence, because they were basically saying, you know, this is a core religious practice. You just have to be hands-off, state. And that's not really the framework. Is that responsive to your question?
Yes, thank you.
Okay, sure. Simon?
Hi. So I was thinking about what you were talking about with Josh about how the court should treat the photos of people not complying with the original regulation.
Mm-hmm.
And it's kind of interesting that the way that the city decided to handle people not complying was not to enforce the original regulation, but rather to create a more restrictive regulation. And on the one hand, I can see why they would do that. You don't really want to be in the position of arresting Christians on Easter. You know, it wouldn't look very good. But from the court's perspective, you know, I could see them saying, why didn't you just enforce this? You know, the church, it's not exactly that the church isn't doing things right, it's that the parishioners aren't complying. So you could have just enforced the original regulation.
That's interesting. I mean, I suppose the government would say they don't care about the past behavior. It's done. Whatever public health consequences have it caused, it has occurred, and they're now going to deal with that down the line in hospitalizations. But they are really trying to do what they're really worried about is Easter, and they're expecting a huge number of congregants, and maybe they're worried about the expressive effects, right? If other churches see this church being able to do it, they're going to start doing it. And so I think from the government's perspective, it just genuinely had no interest in arresting people for this kind of behavior. And one might also think, you know, arresting people is a really terrible public health response because it's putting them in small locations. One of the things about the state of emergency situation we find ourselves in is that the ordinary tools of criminal law that we use to enforce these kinds of norms are themselves affected by the crisis we're facing. So it's arresting people is like really bad behavior for the government right now. It creates its own public health menace. This is a period where we should be seeing severe decarceration. We're seeing some of it, but not nearly as much as we should. Anyway, so you could imagine that the city of Louisville, they do do not want to do that. This isn't about penalizing bad behavior. Now, maybe the court presumably the court would have been more being okay about that, given that this is that they were in violation of the CDC guidelines. I'm not sure. What is true, though, in both the Louisville case and in the New Mexico case is what you see in the government's actions is a lot of effort to be solicitous towards religious groups. The government doesn't want to intrude upon religious freedom, or at the very least, it doesn't want the kind of political fallout that will happen if it's seen to be targeting religious groups. And so in all of these cases, the government is really trying very hard to be respectful. And so even in the Louisville case, you know, one of the things that was so confusing in the litigation is the mayor, in his statements, he said multiple things, some of which sounded like he wasn't going to enforce the order. He's just trying to warn people and implore them not to do this kind of thing. And then in other cases, it sounded like it was more threatening. And I think this reflects sort of this deep anxiety on the part of the government about how to treat religious groups. And so not only is arresting a bad public health measure, but politically it would have been terrible for Louisville if it's going after Christians, arresting them for worshiping. Terrible. And so I think that was just off the table. And so the difficult question is, and I think this is genuinely a difficult question, as the conversation with Josh suggested, you know, what do we do about prophylactic measures? It's very easy to say, well, we'll just punish people after the fact, right? That's our ordinary practice. We're going to allow a lot of freedom. And then if you do violate the criminal law or whatever the relevant law is, we're going to put you in jail. But that's no longer on the table right now. Okay, the ideal public health measure is always prophylactic. It's always in advance, and we're not going to use the tool of jail. We're going to use other mechanisms, maybe fining, but maybe public, warnings, these kinds of expressive messages. And so that's why these sort of much more difficult questions arise. Silver?
Hi.
Hi.
So my question is so similar to Simon's that maybe I should have put my hand down, but I was just wondering, like, what was at stake? Because I thought the injunction was against the government being able, in the Louisville case, just to be clear, it was against the government being able to come in and record the license plates of the worshippers. And to me, I interpreted that not as arrest, which, as you just said, it would be terrible in all kinds of ways, but rather just like a prophylactic measure. So like maybe it could be, what I'm envisioning is it could be like security guards that we do have now outside of takeout restaurants, outside of grocery stores, just enforcing the 6 feet order, and telling people to, like, if once they see people violating, to, you know, step in with a mask on, of course, and say, hey, please step away from each other. And I wasn't sure, you know, to me that seems like not an infringement on people's ability to worship as long as it's in a safe manner. Like, yes, you may not be able to have like the same sort of physical intimacy or closeness as you would normally have in a congregation, but that's sort of like the whole point. And I don't know, I don't see why they couldn't have had the service without that measure.
Well, so you don't think that there's, so imagine this scenario, say, think maybe it's not a church, maybe it's a distant group, a political group, say, that's meeting. And just in order to enforce the public health measure, there's a police officer that stands at the front of the group, at the front of the room, and takes down everyone's name, social security number, and maybe their address. So to me, that seems kind of threatening, because now the government is indicating that it's watching you, it knows you're part of this group, and it's going to follow up on, you know, it's going to check in and see what you're doing. It's a sort of very, it feels very, very intrusive on liberties. And so I think the church read this as a warning or a threat that the government of Louisville is going to be paying attention to the bad behavior of the members of the church, and then maybe later was going to penalize them for it, or was going to follow them around, was going to surveil them. And so the parishioners, the church, viewed this as sort of really threatening invasion of their civil liberties. Now, under the Fourth Amendment, there's no problem with this, because this is all out in public. The government is just taking down license plates like it can do, like anyone could do if the church, if the cars were parked. So there wasn't really a Fourth Amendment problem, but I think there was a sense that this is really targeting of religion.
Okay, sorry, you couldn't see me, but I was nodding along. Yeah, I think that does make a lot of sense. I was just, I don't know, just trying to find sort of like a mediatory way of still protecting the health of everyone, but also not having that coercive measure. And I guess like if the mayor's order was so unclear or so, I guess, ambivalent about what the action was, and maybe that makes a lot more sense as to like what the threat was.
Yeah, I mean, one of the reasons why this case has attracted so much attention and I think criticism is because I think there is this view among the people who are critical of the opinion that the governor of Louisville, the mayor, was really trying to do the least restrictive thing while still protecting public health. All he was trying to do was like see what goes on, and if there is bad behavior, if there is dangerous behavior, follow up to make sure that, to do contact tracing, essentially. That is what he was trying to do. Even still, the court is invalidating what the mayor is trying to do. And so it has been perceived as an order that suggests a real, a court willing to really constrain what seem like totally valid public health measures. But in part, it may be because of the prophylactic nature, that the court was really worried about the government distrusting what the church said it's going to be doing. As I said, I think I disagree with the result. I'm somewhat more sympathetic to what the judge was up to.
So maybe the lesson is for executives not to record license plates, but rather to say, well, we're going to have individuals just gently enforcing to make sure you're not within 6 feet.
Maybe, yeah. it does put I do think it puts mayors like the Louisville mayor in difficult positions in the future. I mean, I think so. But the onus is on the government to explain the reasoning behind what it's doing. In all these cases, what the legal framework makes the government have to do is give a good reason why this isn't discriminatory and explain exactly why, we're treating different groups differently. Anna?
Thanks, Professor. Can you hear me okay?
Yeah. Hi.
Okay. So I was wondering, and I apologize that I missed the first few minutes of the discussion, so perhaps this was covered, but I've been wondering a lot about religious groups whose beliefs would make unavailable to them certain technological substitutes for in-person worship. And you mentioned, I think one of the churches in one of the cases was talking about needing more than 5 people to do the AV setup and looking for an exception there. But I also wonder, about the extreme opposite people, Amish groups or certain Orthodox Jewish groups who would say, we can't use video technology or even a phone call during our during the Sabbath or for our religious services. I would guess that an effort to make exceptions for them would create a establishment clause problem. But I don't know if there's ways around that.
Yes, I mean, so I'm not going to talk about statutory law because it's complicated state by state, but just from a constitutional perspective, yes, this is the bind that the discrimination framework puts on religious groups and on governments. So in general, the rules are, right, if it's a neutral law of general applicability, we're not going to worry about a disparate effect on particular kinds of religious groups. This is really in some ways the purpose of the rule. So if you happen to have an idiosyncratic religious practice, that means that a rule that is okay, that others can work around, you cannot work around, the constitutional law does not care, so long as the rule is enacted for legitimate government purposes and there's only an incidental burden. And so it can have really terribly disparate impact on particular kinds of religious groups depending on their views, their practices. And so in response to that, you do see governments all the time trying to do workarounds. In fact, in the New Mexico case, there is this effort to work around. There's these bunch of meetings, I hope socially distanced meetings, but in-person meetings between the government and the church, in which the government is bending over backwards. So the church says we need at least 30 people to do the live streaming, and the government says, well, okay, how about 20? Even though this is totally against the New Mexico law. So I was struck by that because what? You just said that no more than 5 people, and now you're saying 20 all of a sudden for this church. But it's because the government does want to have a nuanced rule to allow religious liberties to flourish as much as possible. And if the church is making this big argument about how it needs more than 5 people, well, the government wants to go along with it. But when I read that, and that doesn't come up because they end up not agreeing, and so this doesn't happen. But if they had, it does raise all kinds of establishment clause problems, because now all of a sudden the government is favoring a particular religious group and implicitly disfavoring others who don't get the special exemption. And so there is this bind between the free exercise claim and the establishment clause claim. Now, in a case like that, though, it's not obvious to me that anyone would bring an establishment clause claim. And so I actually think that there's a lot of this kind of preferential workarounds that happen all the time, but never make it to the courts because the other religious groups don't think that they're being really harmed, and so they don't bring a claim, and the church itself is definitely not going to bring a claim. And so I think that's probably why the New Mexico Secretary of State felt like they could make this kind of offer, but on its face, from a constitutional law perspective, it does feel very troubling. Yes.
Yeah. Thank you.
Great point, sure. Any other hands? Okay, am I missing anyone?
I don't think so. If anyone else has another question, this is your chance. We have a few minutes.
Yeah. Okay, well, thanks everyone.
Thank you, Professor Lakier.
This was fun. I hope everyone's doing okay, and let me know. Stay in touch. Bye.
Thank you. You too.
Bye.
Thanks, everyone.